On the channel, I've been getting a lot of questions about how to apply the postal rule, so I wanted to post a video clarifying some finer points on effectively using the postal rule when negotiating contracts. Here it goes. The postal rule in contract law is a principle that dictates when acceptance of an offer is considered effective if communicated by post. According to this rule, acceptance is deemed valid and binding at the moment it is posted, even if the offeror has not yet received it. This contrasts with the general rule that acceptance must be communicated to the offeror. Key points of the postal rule include: timing of acceptance. Acceptance is effective when the letter of acceptance is posted, not when it is received by the offeror. This means that if the acceptance is sent and the offeror later revokes the offer before receiving the acceptance, the contract may still be valid. Applicability. The postal rule typically applies only when post is an accepted means of communication between the parties. If the parties have agreed on a different method of communication, that method takes precedence. Exceptions. There are exceptions to the postal rule. For instance, if the offeror specifies that acceptance must be communicated in a particular way, such as by email or in person, the postal rule does not apply. Additionally, if the letter is lost in the mail and never reaches the offeror, there may be no contract. Historical context. The rule originated from cases like Adams v. Lindsell in 1818, where it was established that a contract is formed when the acceptance is posted, highlighting the need for clarity and communication methods in contract law. Overall, the postal rule provides certainty in contractual agreements where postal communication is used, ensuring that parties are protected even when there may be delays or issues with the postal service. However, you can't simply send someone a letter in the mail, have them sign for it, and claim there's a binding contract. Contract elements under the Uniform Commercial Code must still be met for validity. The elements of a valid contract typically include: offer, a party proposes terms to another party. Acceptance, the other party agrees to the terms of the offer in a clear and unequivocal manner. Consideration, something of value is exchanged between the parties, such as money, services, or goods. Mutual assent, both parties must have a mutual understanding and agreement on the terms, often called a meeting of the minds. Capacity, parties must have the legal ability to enter into a contract, meaning they are of legal age and sound mind. Legality, the contract's purpose and terms must be legal and not violate public policy. Written form, while many contracts can be oral, certain types, such as real estate agreements, must generally be in writing to be enforceable. These elements ensure that a contract is valid and enforceable in a court of law. Under the postal rule, a rejection of an offer is only effective when it is received by the offeror, not when it is posted. This means that if the offeree, the person receiving the offer, wishes to reject the offer via postal communication, they must ensure that the rejection letter reaches the offeror. Key points regarding rejection under the postal rule include: effective rejection. A rejection is only valid when the offeror receives the letter of rejection. Until then, the offer remains open, and the offeree can still accept the offer if they change their mind. Simultaneous communications. If the offeree sends a rejection letter and later sends an acceptance letter, the acceptance can still be valid if it is received before the rejection. This can create confusion, but typically the first communication received by the offeror, whether acceptance or rejection, will determine whether a contract is formed. No automatic rejection. Simply posting a rejection does not terminate the offer. The offeror must actually receive the rejection for it to take effect. Use of alternative methods. If the offeree uses a faster method, such as email or phone, to communicate the rejection, that communication would be effective upon being sent and would negate the need for postal communication. To effectively reject an offer by post, the offeree must ensure that the rejection letter is delivered to the offeror, as the postal rule does not apply in the same way to rejections as it does to acceptances. So, those are some of the rules governing the postal rule and how to use it effectively. You can't just send a letter, have the recipient sign for it, and say, voila! We have a contract, and you owe me $1 million. Equitable laws of contract enforcement still apply when using the postal rule.